Good morning or good afternoon, depending on where you are dialing in from today. I am Shadi Salehi. I'm the director of the Trust-Based Philanthropy Project. Really pleased to have you all on this morning or afternoon on our session about the legal considerations of trust-based philanthropy. I'll be inviting our speaker, Jean Tom, to introduce herself in a brief moment. I'll just do a little bit of housekeeping before we get started. We are recording this session so that we can make it available to those who were unable to attend. So if you don't want your image recorded, you can remove your video functionality, but we do welcome your faces. So if you want to be seen and want to be engaged with us, please do turn on your video camera, but no pressure. If you are just arriving, please make sure to mute yourself. Just so we can have kind of clarity of, just so we can hear everything clearly. But please do feel free to ask us questions throughout the presentation today. We will have a designated section at the end for questions. We've also woven in a lot of the questions that we got when you registered. So we'll be trying to address a lot of those questions throughout the session today. But of course, you might have questions that pop up as we're talking. So we welcome you to chat those in the chat box. I will be monitoring that regularly to make sure that we're bringing those questions in at the appropriate time. If we don't get to your question right away, please know that we will do our best to bring it in toward the end of the session. I think that's it for housekeeping. And I'm really glad to invite Jean Tom with Davis Wright Tremaine LLP to join us today, because when it comes to trust-based philanthropy, we often get a lot of questions about, well, what's the legal requirement? What is the, kind of the base level kind of due diligence that we have to do in order to be legally compliant? So we're thrilled to have Jean Tom here today, who is here to answer a lot of those questions and to assure you that a lot of these trust-based practices are fully legal. There's some nuances that we'll be digging into today, and of course, addressing a lot of the questions along the way. I'm going to get us started with just the broad strokes overview of trust-based philanthropy. Broadly, this is a values-based approach. We really, before digging into the principles, it's important to recognize that trust-based philanthropy exists within an ecosystem, and it hinges upon relationship. The whole point and kind of purpose behind a trust-based approach is to acknowledge the power imbalances that exist between funders and grantee partners, and to proactively work to alleviate those power imbalances by prioritizing a relational approach, leading with trust, centering relationship, approaching the work as collaboration with humility and curiosity, a commitment to redistribute power and recognize that nonprofit leaders are experts in the work that they do. They are partners in the collective effort to advance the goals of your grant-making organizations. And of course, ultimately to work for systemic equity. This is a core value of a trust-based approach, recognizing not just the inequities that exist between nonprofits and funders, but also kind of the greater systemic inequities that exist and philanthropy's role in either perpetuating that or alleviating that. So these are the core values that we lead with. It's the foundation of a trust-based approach. And we think of it as an ecosystem because the idea is this work is ultimately about relationships. We can't do this work if we weren't in relationship with one another. So if we really center trust and mutual learning and humility within those relationships, it can kind of ripple out into building more relational organizations and ultimately advancing a more kind of equitable society. That's the big vision, but recognizing the role that philanthropy can play in setting that example. And of course, you might already know that there are 6 principles to a trust-based approach. They are all here. These principles are the core embodiments of how to fully embody trust-based values. These practices look different for different organizations, as you may have heard in our past sessions. But ultimately, these are kind of the core fundamentals of how to embody a trust-based approach. And often, the legal questions that we get tend to relate to principles 1 and 3. So, what are the legal implications of giving unrestricted funding to what types of organizations? How does it work to make it multi-year? And then also with the paperwork, we get a lot of questions around, well, what is the bare minimum that is required legally in terms of documentation? The other principles are kind of supportive ways of doing the holistic practice. We'll be referencing some of those principles as we talk through the legal implications. But of course, it's really, most of the questions are kind of relevant to those principles 1 and 3. Again, these practices, when they're practiced collectively and holistically, we've seen among funders that practice all these practices, it can be a really great way to alleviate power imbalance, build trust with nonprofit partners, and deepen learning over time about what it takes to do this work, and ultimately the benefits of freeing up nonprofits to focus on their mission critical work. So today we've got Jean Tom here with us, who's a partner with Davis Wright Tremaine LLP. She's based out of San Francisco. She is a seasoned attorney and advisor to nonprofits, philanthropists, social entrepreneurs, and foundations, really helping navigate a lot of the kind of legal red tape that we all have to deal with in this sector. What I particularly love about Jean's approach is that her vision in doing this work and providing these services is ultimately about freeing up organizations to focus on their mission. So values-wise, we found Jean is just such a great thought partner in this work with very aligned values around just kind of, let's free up organizations to focus on their mission. So without further ado, I'm going to hand it over to Jean to take us from here.
Thanks so much, Shadi, and it's great to be here with all of you today. So I come at this work from the perspective of having advised a few private foundation clients who've actively been exploring and pursuing these trust-based philanthropy practices. And I'm bringing to you the experience I've had as a legal advisor and outside counsel and helping them consider the practices and to think about how they can retool and adjust their grant making processes to align with the principles in a way that's consistent with legal requirements. And I just want to share, it's been an interesting journey in both learning about trust-based philanthropic practices and also reflecting on the impact that they've had on the advice I provide more generally as a lawyer to nonprofits and foundations. Because in many ways, and I think the other lawyers who might be on this call can relate, our job as lawyers is, one way of thinking about it is to protect our clients from risk. So, one view of how to be a good lawyer is to, create practices and draft contracts that protect foundations as much as possible from downside risk and also in ways that are most favorable to our foundation clients. But one of my clients asked me, he said, contracts always seem to be about when things go wrong. Can't we have contracts that reflect what happens if everything goes right? And the lawyer inside of me reacted and said, you don't need a contract in that case. You really need a contract when things go wrong. But then as I sort of step back to think about it more, risk mitigation is only one part of a lawyer's job. The other part of my job is helping make sure that I can help my clients achieve their goals and their mission consistent with the law. And so working with my clients to adopt trust-based philanthropy practices has really made me think as a lawyer more creatively and holistically about how to balance the risk management side of things with the partnership and relationship building side of things, to design contracts and practices that treat grantees as trusted partners and collaborators who are working with my clients towards their mutually shared goals. So just wanted to share that as sort of a backdrop to some of this work. So I guess with that background, let's jump in. This first slide just acknowledges the fact that when we talk about funders, that's a pretty diverse term, and there are many different types of organizations and also individual funders that have different tax characteristics that might apply to them. And I do think that the trust-based philanthropy principles can be adopted by each of these types of funders in accordance with the law. Today, we're going to focus, I think, mostly on grant making by private foundations because they're the ones that are subject to the strictest regime under federal tax laws. If they make a misstep, they can be subject to penalty excise taxes. Many of these other groups mentioned here will likely not suffer those excise taxes, but and they may have, you know, larger questions of, oh, if you engage in egregious practices, will that jeopardize your tax exempt status? But I think to the extent that practices that we talk about today are okay for private foundations, they will generally be okay for these other categories as well. Shadi, did you want to ask a question?
Yeah, we're gonna do a little poll just to get a sense of who's on the line. So if you could just let us know what type of grant making organization you represent, so we can just get a sense of the mix in the room. And of course, if you're not a grant making entity, or if you're here representing a nonprofit, just curious, we have a couple options at the bottom that you can fill out. So we'll give a couple seconds. And Jean, I'm gonna ask you to read back the report, because for my view somehow is not showing me the data. So if you could just report it out to the group when I end the poll.
Sure.
So we'll give folks about 10 more seconds to fill this out. All right, we're gonna end the poll. All right.
Okay, so it is as we suspected. Looks like 70% of people here are from private foundations. Another 16% are from, you know, public charity foundations or community foundations. We've got a few grant-making nonprofits, NGOs, as well as a few individual donors as well, and LLCs. So great. That's really helpful to know who's in the Zoom, as it were. Next slide, Shadi. So I thought I would start today by talking through the 3 big picture questions that my clients have asked me when considering adopting trust-based practices and principles. And these also reflect some of the questions that we got in advance. So there are these. Number 1, is trust-based philanthropy something you can do consistent with legal requirements? Obviously, that's a key question. Second, how do I balance accountability with these principles? And then third, what risks does trust-based philanthropy create for my board and my organization? So let's take it from the top. Can I engage in trust-based philanthropy in a way that's consistent with legal requirements? And the short answer, I would say, is yes. As we'll get into further, trust-based philanthropy isn't about blindly trusting grantees that you barely know, or doling out money willy-nilly. And I think it says, I heard Pia Infante say, it's not just leaving a pile of money in the middle of the road and seeing what happens. And it isn't also about eliminating contracts or grant agreements, although in certain circumstances that could be possible. And it's also not about having less accountability in your grant making. What I think it's really about is it's about showing up differently in the practice of philanthropy with the values that Shadi described underlying the work, leading with trust rather than suspicion, engaging and collaborating with grantees with humility and curiosity, and acknowledging that no one has all the answers, which is become all too apparent during these times. And then achieving the goals through listening and collaborating and prioritizing open and healthy relationships with grantees, where they're comfortable being vulnerable with funders about what hasn't worked, so that you can work together to support what does work. And consciously thinking about how to share and cede power to grantee partners and communities who are closer to the issues you're trying to address. And also just being conscious of the systemic inequity, you know, both in the philanthropic relationship, but also in greater society, so that we can work to change practices and behaviors that might perpetuate harm. And, you know, as a lawyer, as I think about these values and these practices, I've really concluded that none of these values is inconsistent with the legal rules that foundations have to abide by. And I'm going to go through those more specifically later. Certainly, there are some requirements that foundations do have to abide by under the tax code and state nonprofit laws, but I don't think they're fundamentally at odds with the trust-based values that we are talking about today. And we'll definitely go into that further. Another big question we've gotten is, how do I balance accountability with these principles? And again, I think there is nothing in the principles and values that says don't hold your grantees accountable. I think the question is really more, how are you going to hold grantees accountable? Or what do you think your accountability measures help you achieve? And I think about it some similar ways as I am thinking about parenting my teenager this summer during a pandemic. How am I going to hold him accountable for having a somewhat productive summer? Am I going to do it by requiring him to complete a daily checklist of activities, reporting to me on his checklist completion, and then having dire consequences of cutting him off screen time if he doesn't complete everything on the list? Or is it by having a dialogue with him about what he wants to accomplish this summer, setting some goals and structure collaboratively with him, and then checking in with him periodically to see how it's going on, what's working, what's not working, and hopefully knowing we've got to adjust expectations perhaps somewhere along the line, and mutually hopefully driving towards our shared goal of him not having a totally wasted summer. Similarly, I think with grantors and grantees, it doesn't mean not having anything on the back end or along the way to see what's being done with your grant dollars. But I think it's imagining new ways of doing this that's less paper intensive, less about checking the box, and more about relationship building, collaboration, and mutual learning. So perhaps there are more check-in phone calls and conversations with grantees about how things are going, and having them submit fewer written reports into the Salesforce system that no one reads, but they are required to be submitted before the next grant installment can be paid. Or as one of my clients who engages in a lot of local place-based funding says, I don't really need a written report. When I walk through town and talk to community members and grantees, I can see the progress that's being made with our grant funds with my own two eyes. So, and also, as I've been working on this, if you do want to have some sort of written report, making sure that the metrics that you're asking grantees to report on are ones that the grantee really thinks are the right ones to measure their work by. I recall working at a youth development program on the Lower East Side in New York a long time ago, and a funder really wanting us to collect report cards from all of our program participants so they could track our program's potential impact on the participants' grades. And the funder not realizing what a difficult ask that was, with many of our kids coming from broken homes and coming to our program as a refuge, and where our program's impact on their grades was really not what we were focused on. And then I recall the funder being very angry with us when we couldn't deliver the report cards. So, certainly your foundation may have a specific theory of change that it wants to measure, but, I think these principles perhaps ask us to think about, does this really line up with the grantee's goals? And also to make sure that your accountability measures are not, in fact, hampering your grantee's ability to do their work. So again, I don't think the practices and principles are inconsistent with accountability, but perhaps it's changing the way that accountability is accomplished between funder and grantee in a more mutually beneficial way that's focused on dialogue and a deep effort to understand what does and doesn't work, and investing in the grantee's success that ultimately hopefully moves the work forward for everyone. And the final opening question is, what risks does trust-based philanthropy create for my board and my organization? So I think this is an interesting question. And some of it depends on what risks you're thinking that you really need to protect people, protect your organization and board against. So I guess starting with the board, your board members are fiduciaries of the organization, of your foundation, which means they're keepers of the organization's mission. And they're also stewards of the finances to make sure the funds are used to achieve your mission. So they generally have to exercise 3 fiduciary duties under state law. The duty of care, which means they have to show up, pay attention to the organization's operations and finances, and to try to make decisions that other prudent people in their situation would make. They also have to abide by the duty of loyalty, which means they have to act solely in the best interests of the foundation when making decisions for the foundation and recusing themselves from conflicts of interest situations. And then there's the duty of obedience, which means they should ensure that the organization is staying faithful to its mission and to compliance with laws. So in short, the board has to exercise care in making decisions for the organization that are in the best interest of the organization and help to ensure that your foundation's funds are used in a way that furthers and propels your mission. And if you're a grant-making foundation, I think this really means finding grantees out there that you believe, through your foundation's research, homework, and due diligence, are the ones that are making the most difference in achieving your mission, and then hopefully resourcing and equipping those grantee partners to be as successful as possible, that in a way that most effectively carries out your shared mission. And in many ways, this is what trust-based philanthropy is telling you to do too, because it's not asking your boards or foundations to be indiscriminate about who to fund. Its first principle is, in fact, do the homework or practice. Figure out who you truly believe is going to do the work, the kind of work that makes a difference, and be proactive about that. And do the research. Like that's one of the principles. So all that homework allows you to figure out which grantees you should place your trust in with the grant funding. And I would say that that is a key practice in reducing the risk in your grant making. And once you've made the decision to fund the grantee, there's nothing in a board's fiduciary duties that require the foundation to only engage in short-term restricted project funding, or to require onerous reports, or to require grantees to submit elaborate new proposals for a renewal grant. While it might seem like an exercise of a board member's duty of care to require a short leash on a grantee so that you feel like you have control over what they're doing with the money, would it still be consistent with a board member's duties if they learn that such practices actually hindered the grantee's ability to achieve their mission? And what if most nonprofit leaders shared that some of the more traditional grant-making practices take away from their ability to do their work, and keep them in a starvation cycle of constantly having to submit proposals and reports rather than focusing on their more important work of serving their communities? Or don't give them the flexibility to pivot if, say, a global pandemic happened to strike so that they had to shift all their programming. So, what would a board say if, they learned that unrestricted multi-year funding actually allows grantees to build the capacity to more fully execute on their mission and vision, which the foundation happens to share? So, I don't think that trust-based philanthropy puts a foundation or its board more at risk, or at least it doesn't increase the risk of not successfully achieving one's mission or of being irresponsible stewards of the funds. I think the onus is still on the board and the foundation leadership to figure out at the front end who you want to be your grantee partners and who you want to bestow your trust in. But then once you get there, I think it's resourcing them in the way that you think will help them best achieve your shared goals. So next slide, Shadi. So I guess just to get a little more granular about some of the specific legal questions people have posed, one of the first ways my client approached these practices was to ask me the question, Jean, what are the minimum legal requirements that we have to abide by? Because they really were wondering, like, what can we strip away? But what's the kind of baseline, the furthest we could go, because the law says we have to, we can't get rid of certain practices. So, and here I'm talking about both the legal requirements under federal tax law, given that you're 501c3 organizations, as well as state nonprofit law. And here the hint is, do the homework, right? So it really depends on the kind of grantee that we're talking about. So you need to figure that out as your first step. And, and this is actually one of, again, the trust-based philanthropy practices: due diligence, do the homework. Check your publicly available databases and figure out with your grants managers are doing this anyway, what kind of grantee you're funding. Because that will drive actually some of the answers to this question. Next slide, Shadi. So what I'm here to tell you, and I think this is probably the biggest takeaway, is that if you determine that your grantee is a 501c3 public charity or a governmental entity, and asterisks there because the one exception is if the grantee is this ugly type of entity called a type 3 non-functionally integrated supporting organization, but those are pretty rare. But if it's generally a 501c3 public charity, all of the recommendations of the trust-based philanthropy principles are open to you. And I'm going to assume here that most of the grantees of your foundations are going to be these 501c3 public charities. If they're not, we're going to talk about what to do in the next slide. But here, if you've determined that your grantee is a 501c3 public charity, there is absolutely no issue with providing them a multi-year unrestricted general operating grant. If there is a grant, if that grantee is a 501c3 public charity, there is no need to fund specific projects. You can give them an unrestricted grant so that the leadership of the nonprofit can decide how best to deploy the funds that year. It allows you to fully put your trust in that leadership. Next, there is no legal requirement, and this may surprise you, that there be a grant agreement or grant letter. You could literally cut them a check if they're a 501c3 public charity without any written agreement. And in fact, you know, this is what many smaller family foundations do. People have called it checkbook philanthropy, like an annual check to the founder's alma mater, you know, an annual check to the ACLU, you know. And while that term checkbook philanthropy may have a somewhat pejorative connotation, implying non-strategic philanthropy, as the term demonstrates, there is nothing legally wrong with foundations engaging in it. So maybe it can make a comeback under trust-based philanthropy, but with a strategic twist. Mm-hmm. And if you engage in grant making that way, just sending out checks with nothing more, I want to note that that inherently means that those funds are unrestricted funds, unless you're responding to a specific solicitation from the nonprofit. But if not, if you're just writing them a check, you did not put any restrictions on their use of those funds. So they'd be free to use those funds in any way they see fit in furtherance of their mission and charitable purpose. And as we know, these are the most precious dollars to nonprofits these days. So as a lawyer, I'm just going to say I'm not necessarily an advocate in all circumstances of no grant agreement or grant letter to accompany the check. I'm just explaining that from a legal standpoint, there's no requirement that you have one if you're making an unrestricted grant to a public charity. There might be lots of other reasons you might want to have a grant agreement. You know, for example, if your foundation has a cohort of grantees and you want to bring them together, you know, as a network for occasional, you know, meetings and peer learning, or if you want to clarify how you want the foundation's grant to be acknowledged, or say you want to enshrine certain trust-based principles or practices like regular check-in calls, you know, that's totally fine. And oftentimes I do think, you know, having a contract enshrine these understandings is useful as a way to document your meeting of the minds.
And Jean, we are getting a question. What are the liability concerns if you don't have a grant agreement? What are there kind of liabilities to be aware of?
You know, I guess I'm just trying to think about what kind of liabilities would occur. I mean, I think the grantee is a 501c3 public charity, so they can only use the funds for 501c3 purposes. You as a private foundation have determined that they are a 501c3 public charity, so there's no tax liability for you. That is a totally permissible grant. And, you know, we may talk about you know, what reporting you might need to keep from a IRS standpoint. If they were, say, to come audit your foundation, you want to keep records on the due diligence side of things to confirm that you checked that their tax status of the grantee. But once you've done that, you know, there really is not any kind of potential tax liability there. You as a private foundation have made a grant to a C3 public charity grantee. There, you know, there is not a tax liability there. You know, other liabilities, you know, we'll get into a question later about that someone shared about indemnification, whether that is needed in a grant agreement and whether that is inherently contrary to trust-based philanthropy principles. You know, I have not seen that many funders want to be indemnified by their grantees for liabilities, because I think it is quite rare for a funder to be sued for the actions of a grantee. You know, I mean, particularly if you're giving an unrestricted grant to them, you know, it's really hard to attribute liability to the foundation for anything that that grantee might be sued for. And sure, anybody can sue anyone, right? But in order for liability to attach to the funder, there really isn't, you know, anything that the funder is doing other than supporting those activities. That I don't think that's enough to attribute liability to the funder. So I guess what I'm saying is, you know, when I think about unrestricted grant making from a funder to a grantee, you know, I think the grant agreement is really just to clarify any expectations you might have, but I don't believe there are any legal, there's no legal driver for that to protect you from liability.
Thanks,
Does that
Jean.
answer the question? Yeah.
Yeah, we're getting another question, just a clarification. So if with an unrestricted grant, if a grantee misuses the funds, does that responsibility fall fully on the grantee?
Yes, it does. I mean, you've given them an unrestricted grant, so they can use the funds for whatever is consistent with their mission, charitable purposes, and 501c3 status. So in order for them to act inconsistently with your grant, they would really need to be going beyond their own charitable purposes or 501c3 status. And that will certainly create problems for them, but there is no attribution back to you as the funder for them violating their own charitable purposes or 501c3 status. So yeah, I think that's an important question. Thank you.
Yeah, thank you for that question. On a related note, we did get a question about how does this apply for organizations that do advocacy work? You know, are there additional considerations there with an unrestricted grant?
Yeah, and that was definitely a question we're going to get into, but I can talk about it now. So I'm so glad someone has asked this, because actually another message I want to leave people here with is that funding groups that do advocacy with a general operating support grant or an unrestricted grant is actually the best way to do that kind of funding. So as you all probably know, private foundations themselves are prohibited from directly engaging in legislative lobbying, which is what a lot of people think about advocacy as. So, you know, pushing for the passage of a bill. And they're also, private foundations are also not permitted to earmark any grants for lobbying activities. But there are two ways clearly specified in the IRS Treasury regs that private foundations are permitted to fund grantees who do engage in lobbying. And the first big one is to provide a general operating support grant, an unrestricted grant. The IRS says that if you do that and you don't earmark the funds for lobbying, even if you know they're going to be using those funds for lobbying and advocacy, that is not attributed to your foundation in any way. You don't need to engage in any tracking, et cetera. That is a fantastic way to resource your grantees who are lobbying. And in fact, you know, we've heard that, you know, in recent decades, you know, conservatively leaning foundations have deliberately utilized this strategy to resource their nonprofit grantees for lobbying. So it's a strategy, and it's one, hopefully, I think and hope maybe more foundations will utilize, because it's a great way to drive dollars to their grantees. The other way to do it is more complicated. If you're funding a specific project, and so say you don't want to just give an unrestricted grant to your nonprofit grantee that you know is doing lobbying, you can fund their specific project, but you have to ensure that they provide you what's called it's called the project budget method. They have to provide you a budget for that project that shows line items that include non-lobbying activities that are at least the size of or larger than your grant and your foundation's grants to that organization for the whole year. If the non-lobbying amounts are larger, then that grant is permissible, and you're not also, again, earmarking the funds for lobbying. So that's called the project budget method. That requires a little more paperwork, a little more tracking. So it's definitely possible as well, but a little more sort of paperwork intensive than the general operating support grant.
Another question on this bullet. So does that mean that a C3 can transfer their unrestricted gift to their C4?
A C3 can only transfer funds to a C4 restricted for C3 related purposes. Mm-hmm. So say the C3 did get unrestricted funds from you, they can re-grant those funds to the C4, but they have to limit the use by the C4 of those funds to C3 permissible purposes. So the C4 can't use them for political campaign intervention, but they could use them for lobbying. And I think in that case, there is attribution back from the C4 to the C3 up to the C3's own lobbying limitations. But so it's possible, but it's not a way to sort of like route funds and sort of alleviate the C3 restrictions and get them into a C4. So I hope that answers that question.
And I know that you're going to get to it in a minute, but we've got a little over 20 minutes left.
Okay, yeah.
We are getting a question about what is the consideration for fiscally sponsored projects? What looks different?
Yeah, so great question as well. So fiscal sponsors or fiscally sponsored projects are usually held by fiscal sponsors that are 501c3 public charities. So that's great. So the only kind of nuance here is that, so I should mention, unrestricted funds and restricted funds, they're legal terms, but they're also accounting terms. And what the accountants define restricted funds as are funds that are restricted by a donor in the way the organization that's receiving them can use the funds. It's either in what they can apply the funds to or when you could spend the funds. And so if there's any kind of restriction like that, those are viewed as restricted funds. So when a funder wants to support a project that's fiscally sponsored by a 501c3 fiscal sponsor, it's kind of impossible for the funder to give a truly unrestricted grant to the fiscal sponsor while at the same time specifying that it has to be used for your fiscally sponsored project, right? Because once you're specifying it has to be used for that project, it is, from an accounting standpoint, restricted to that project. And you'd want it that way, right? You don't want the fiscal sponsor to be able to use your grant for any of its fiscally sponsored projects. You want it to be used for the one that you're supporting. So inherently, from an accounting standpoint, a grant to a specific fiscal sponsor is a restricted project grant. But I think, and this also gets back to the lobbying point that I was just talking about, because again, if you want to support a project that is doing lobbying, the unrestricted grant to the fiscal sponsor probably won't work for you, because then you have no assurance that it's going to the project. So in that case, you'll probably need to use the project budget method. But I guess I will say that beyond those issues, you can still, I think, employ the other trust-based philanthropy practices. You can, have the grant to the fiscally sponsored project be unrestricted in how that project uses the funds, right? And you can, alleviate the burdens of reporting, et cetera, to them. So I think that's just the fine nuance that I wanted to point out, is you're not making a, truly unrestricted fund grant to the fiscally sponsored project, but you can still, I would say, employ the other principles, hopefully just as well.
Thank you.
Sure. I guess one final thing is just on the reporting that I wanted to clarify is reports for an unrestricted grant to a 501c3 public charity are not legally required. And I think this is also, perhaps sometimes surprising. I think the IRS kind of takes for granted, as we talked about earlier, that if you've given to a C3 public charity, they can only use the funds for permissible C3 purposes. So no further verification is required. But again, like with grant agreements, your foundation can certainly decide that it wants to have reports, as an engagement tool, as an information gathering tool, an accountability measure. But, really think about, like, what does it serve? What purpose is it serving? One of my clients was just sharing with me today that they had this whole elaborate reporting structure and like weekly lists of what reports haven't been received from their grantees. And you know, the program officers don't even have time to read those reports, but everybody's spending so much time collecting them and getting their grantees to submit them that you know, it's actually to them a relief from the foundation staff side too, that they might be able to do away with them and sort of reimagine a way of really understanding and learning from their grantees about what's working and what isn't working. So let's see, I think I've covered, there was one other question somebody asked previously, whether it's possible to structure a multi-year unrestricted grant for an indefinite period of time. Like, do you have to have grant terms? And, you know, my answer is, again, no, you don't need to have grant terms. Grant terms are really kind of a funder preference. Like, if you want to see the funds spent in a particular period of time, but, you know, there's no particular legal basis for that, particularly for these unrestricted grants. And, you know, so, you know, as we'll get to, for grants to non-public charities, you do need to have certain reporting, and you'll have to report until the grant funds are expended. But you know, you could leave it open to the grantee as to when they want to best spend the funds, whether they want to put them in a reserve fund, a rainy day fund to, you know, get ready for another future crisis. It's a way to definitely demonstrate trust by leaving that up to them. So
I will add, though, on that question, you know, if you anticipate there being an end to the grant, the multi-year grant, then it is important to communicate that. So that could
exactly.
be a time when you do want to put it in writing, if it is a term, you know, if it's a 3-year grant. So really, you know, the key here would be just communication. So
I agree.
Yeah.
I agree. Yeah. And I think there's a question here, is there a requirement that the grant has been fully expended? There really isn't for an unrestricted grant. You know, if they wanted to put it into their reserve fund and use it for the future, you know, that is fully okay. And, you know, I'll share with you, you know, when we get to the next set of slides, you know, for non-C3s, I think a lot of these practices, perhaps, that traditional philanthropy has put into place are maybe driven by some of the requirements that are for grant making to non-C3s. And Shadi, I don't know if you want to go to the next slide. Mm-hmm. And many of you may have experienced them, and people oftentimes will talk about them as expenditure responsibility requirements. And those are IRS requirements that you do have to abide by as a private foundation. If you don't, there are tax consequences, tax penalties. So I think some of these may have sort of made their way into grant making for other, for public charities, and maybe people thinking, oh, these are good practices. But I guess I'm just here to say that they're not legally required for the public charity grants. And so, you know, really thinking hard about what purpose they serve in the public charity grant making realm. But, you know, as we spoke about, and I've alluded to, if your grantee is not a 501c3 public charity, there are certain additional legal requirements that you have to meet. And that doesn't mean, though, that all trust-based philanthropy practices are off the table. You know, there are a few more legal steps required, but I think you can still establish relationships of mutual learning and trust with a grantee. So, okay, a couple of the differences here, and I'm talking about grant making to, you know, non-C3s, to foreign organizations, to individuals as well, to 501c4 organizations. The requirements are, you definitely do need to have a grant agreement. Also, you cannot just make an unrestricted grant to such grantees. And the IRS's rationale is you don't have that same assurance that they can only use the funds for 501c3 purposes. They could, you know, arguably use them for their profit-making arm or their political activity. So you need a grant agreement, and you need the grant agreement to restrict the funds to be used only for 501c3 public charity purposes. However, well, you do need to have written reports. So that's different. And so under the expenditure responsibility rules, you do need to have annual reporting on their use of the funds, compliance with the terms of the grant, and the progress made towards the purposes that the grant was for. So the grantee will need to supply you a financial and narrative report on an annual basis and when the funds are fully expended. The grantee has to keep records on the use of the funds, and then you need to have a methodology and something written into your grant agreement where if they use the funds for impermissible purposes, you can recoup those funds. And also your foundation will have to report to the IRS on its annual Form 990-PF on these grants, and you'll have to keep copies of those grants and reports in your files in case the IRS comes to audit. So those are the IRS requirements. And while this might seem like a lot, I still don't think it necessarily defeats the potential for establishing trust-based relationships with these grantees. You know, beyond compliance with this, you can still engage in some of the other practices. You know, you can, while you can't provide unrestricted funding, you can still define a broad charitable project for which the funds can be used. So it doesn't have to be super narrow. You can still make multi-year commitments. And you can also keep reporting short and sweet and confined to what's legally required, and also reimagine, you know, other ways of engaging your grantees.
Jean, we're getting a couple questions.
Yeah.
One is, what about giving to local government and tribal groups? Are they falling into this category here, or is it a different set of considerations?
Yeah, so there are more complicated rules for giving to tribal groups and local governments, particularly if the funds are going to a particular official, government officials, there can be possible self-dealing rules. If you're giving to a local government entity, however, and not giving to an official, governmental entities are usually defined as public charities, so that actually applies to the prior slide. So I think it's much more open. And some tribal entities are also viewed as public charities. So, you know, those are more nuanced grantees, so you may want to talk to your legal advisor about them, but I would say that they fall more in the public charity camp rather than the non-public charity camp.
Great. And another question about grant making to individuals. Is annual reporting required for the full duration of the grant or just in the years the funding was received? And this specific question is coming from a funder who funds filmmakers who are making films and they're not necessarily expending the funds each year.
Yeah, I have to verify the grants to individuals rules. There are specific Treasury regulations. I don't know if any of the other lawyers on the call know offhand. I believe, I mean, there's definitely a final report required. And there's definitely, without checking the regs, my answer is going to be, I think there's annual reporting required. Yeah, and I'm seeing here that when it comes to defining reports, would a conversation suffice here or must it be written? You know, I think in the case of, as I was saying, you know, non-public charities, and when it comes to individuals and non-public charity organizations, you do need a written report. So, you know, but again, you could keep it short and sweet and, you know, also have the conversation, or, you know, I think I do think that that is required, because I do think it probably requires a signature verifying that it is accurate coming from that individual. So unfortunately, you know, slightly more legal requirements for individuals. Again, that driven by the IRS's view that, you know, we have no assurance that that person is necessarily using them for C3 purposes. So there does need to be a little more verification.
And just to clarify, because there's another question about reporting process. If a program officer kind of has a conversation with the grantee and records the report in written form, then would the does that suffice if the grantee is providing a budget breakdown on use of funds?
That's a really good question. I mean, I think for expenditure responsibility, I do believe that the reports have to be signed by an officer of the grantee, you know, verifying the accuracy of the report. So, you know, unfortunately, I think in that realm, you do need to have them send something to you in writing. You know, I think, although if you know, beyond the specifics that are legally required, you could have the conversation and have the program officer record it. But I think you do need them to certify, and maybe this is what you were getting at, the use of funds, the financials, and the compliance with the grant, and have some statement of the progress towards the purpose of the grant. Those are the legal requirements under the Treasury regulations.
Thank you, Jean.
Sure.
Another question about ER grants, and coming from Jane Ward, and I'm not sure what ER grants are. Maybe you do, Jean.
That's the expenditure responsibility.
Oh, thank you, thank you.
Yeah. Mm-hmm.
So they're looking to make grants to very small, unincorporated, community-based collectives, and they don't have a lot of capacity. Is there any advice on how to do the due diligence and to do ER with these types of very small groups? They're trying to, and they're small grants, so they want to be sensitive to the administrative burden.
Yeah, that's a challenge, right? Because they do fall into this slide of requiring these additional burdens, but again, I feel like, maybe as a grantor, you can supply them with a template, report, so that they just fill it out quickly each year and send it back to you. You'll have a standard grant agreement that hopefully, isn't too complicated or scary. And, due diligence is more challenging. I mean, I think gets back to the relationship point, who, do you have others who can vouch for them and their activities and their impact, and finding ways to be in relation with them so you can understand that they are groups you want to place your trust in. So I mean, I think just you can try to streamline as much as possible, I think, within the rules that do apply to them, I think, is what I'd recommend.
Thanks, Jean. We actually only have about 6 minutes, so should
wow, okay. Let's see, what's on the next slide? I think we've gotten
these
to
are
the questions. Yeah, and I think we've touched on a lot of them. So what are the current legal processes and systems that serve as real obstacles? Well, I mean, I think we've touched on, one of them, which is the expenditure responsibility requirements, right, for groups that are not public charities. Like, there's just no way of getting around them, and, because the foundation will experience a tax hit if you don't follow them. So those are kind of your bare legal minimum requirements for grants to non-public charities. So, if we could get rid of them, that would definitely let us move more towards those practices for grants to non-C3s. So, I don't think that will happen. So that's just what we have to wrangle with right now. What are auditors looking for in grant due diligence? So this is a great question. And in fact, with one of our clients, before we shifted to these practices, we sat down with their auditors and wanted to just make sure we were on the same page, because, while I might be advising them from a legal standpoint that it's okay, I didn't want this to come back to them in audit season and have their auditor say, what? You got rid of what? So, and they actually confirmed a lot of what I shared with you today. Number one, that due diligence on the front end is key. So they really wanted to see that, record and print out that, the foundation checked the grantee status, tax status with the IRS databases or GuideStar, ensure that it's a 501c3 public charity, not a type 3 supporting org, and you have that grant file that you can share with the auditor. And so that's the critical piece. And they confirmed that if it's an unrestricted grant to a public charity, she didn't really need to see anything else. Maybe she wanted to see that there was the board minutes approving the grant, or whatever process you have from a governance standpoint, that that process was followed. So that was one thing. If it's not a public charity grantee, the auditor will want to see all the expenditure responsibility requirements. And then also for grants to foreign entities, they did emphasize, they'll want to see that you've checked the OFAC lists and the specially designated national terrorist watch lists. But again, those should be happening probably in your due diligence already. So, so I encourage you to sit down with your auditors and ask those same questions. And then let's see, what are some, what do we have to do? Let's see, what are some opportunities to use legal tools creatively to advance trust-based philanthropy? I mean, I guess I would point back to what we talked about with respect to advocacy and supporting advocacy through unrestricted general operating grants, because I think that is just a great way to resource the field. So, you know, and if others have other ideas in how to use these tools creatively, that would be great. Please feel free to chime in. Let's see. And then let's see, here's this question now about, does it convey distrust if we include an indemnification clause in a grant agreement? And I think this is a really interesting question. And I think Sean Delaney is also posing a question here about risk. And it says, many grant makers include clauses in their grant agreements that shift liability for harm to third parties to their grantees. Given how remote the possibility is that grant makers can be liable to third parties arising from their grant making, can you comment on the compatibility of this practice with trust-based grant making? Great question. And you know, I would say I would agree with Sean that it is quite remote. I don't necessarily recommend indemnification clauses or risk shifting clauses like this unless there truly is, you know, a risk that's presenting itself. Like, for example, maybe if, say, a funder is funding a building and getting their name placed on the grantee's building, right? And maybe that means that if there's a trip or fall at the building, it's more likely for the funder to be sued because their name is on the building, right? So, or if there's some like sharing of data or intellectual property and the funder wants to be indemnified by claims of infringement, like that the grantee maybe utilized improperly someone's IP, you know, but I think those are, you know, in the general grant, especially an unrestricted grant, I think it would be highly unusual to have an indemnification clause for the very reason Sean mentioned. I think that the likelihood of being sued for a third party is remote. Or if you're going to have an indemnification clause, have it be mutual, right? Have the foundation say, well, if you're going to indemnify us, if you've messed up and a third party sues us, we will also indemnify you if a third party sues you because of our error, right? That at least seems more equitable. So that's just one thought. And
so we are at the 1 minute mark. And I want to stick with our timing here. We do have a couple of things around how to talk to your lawyer about this stuff. Sharing this presentation is a great first step. We will be recording this. Sorry, my mouse is going crazy. We will be recording, or we have been recording this session, so we'll make it available. And we'll also be thinking about producing a resource to accompany this. So I've dropped a link to our survey in the chat box. Please fill that out. If there's things that we didn't get to or deeper topics you want us to explore on a future session or for a resource, please, please, please let us know. I really want to just thank you, Jean, for all of this wisdom, really, really great and detailed feedback. Thanks for being so responsive to everyone's questions and comments. We're getting a lot of comments in the chat box on how helpful this has been. If you'd love to see another session like this or want us to do a part 2, please let us know in the survey. We take your feedback very seriously. And in the meantime, join me in thanking Jean for an awesome session today. Thank you, Jean.
Thank you, everybody. This was, you had great questions, and really excited to be a part of the drive towards these practices. So real pleasure to be with you.
Thank you, everybody. Have a great day.